Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers 911 calls, de-escalation, and false reporting by police, and is brought to us by Mark Domino's channel. Be sure to check out the description below and give them the credit that they deserve. Before we dive into the interaction, I want to give a big thanks to the sponsor of this episode, YouGov. If you've ever needed a quick buck or just a little extra cash on the side to help you pay for your next online shopping spree, YouGov could be your answer. With YouGov, you can earn points by taking polls and surveys about topics ranging from politics and public affairs to products and brands, and convert those points into cash rewards or gift cards from some of the top brands on the market today. Earning money through YouGov is as simple as a few clicks, so get your next tattoo or date night fun started today by clicking on the link in the description. Thanks again to YouGov for sponsoring this episode. On June 24th, 2019, 52-year-old Mark Domino drove his motorcycle to work and parked on the backside of the parking lot. Mr. Domino and his wife both worked at the same retail store in Clarkston, Washington, and his wife drove their car to work and parked on the opposite end of the lot. After Mr. Domino's shift, he went to his car before crossing the parking lot to ride his motorcycle home. As Mr. Domino was looking through his vehicle, a citizen parked nearby, Jody Brunel, noticed him, believed his actions to be suspicious, and called 911.
Police and fire, this is Mallory.
Hi, I'm at the Clarkston Walmart right now, and I just saw a gentleman stop and get in 3 different doors of a car, looking around, and I kind of watched him to see if it was his, and now he's walking clear away.
Okay.
I couldn't see if he took anything.
Okay.
Officer Chris Lors from the Clarkston Police Department arrived shortly after the call and confronted Mr. Domino.
How's it going, man? I'm Officer Lors, Clarkston Police Department. Put your phone down for a second. What do you got in your pocket there? Is that just something hanging off your backpack? What is that, a hanger? What are you doing with that? Is this your bike?
Yes.
It's your bike? You got ID on you?
Why do you need my ID?
Because somebody saw you looking at cars, so I'm here just checking to see what's going on. You got ID on you?
Yeah, I do, but
Okay,
did I do
I'll
anything?
yeah, I'm figuring that out right now. I'll take a look at your ID, though.
You don't need my ID unless I did something.
Okay.
Unless you're taking me in for something
Turn
I've
around,
done.
put your hands behind your back right
what?
now.
For
now!
What? For what?
Turn
For
around
what?
and put your hands behind your back.
For
now!
What? For what?
Before we get started,
108, pick it up.
please review these
You're gonna
items.
You're gonna obey me, or you're
Why
gonna go
do I
on the
need to
ground.
obey you?
Because I'm giving you a lawful order.
For what?
Turn around and put
Did
your
I
hands
do
behind your
anything?
back.
Did I do anything?
Yes. Turn
What did I
around
do?
and put your
What
hands
did I
behind your
do?
back.
What did I do?
Do you want to get tased?
Excuse me?
Turn around and put
For
your
what? Do you know I work here?
Turn around and put your hands behind your back.
Do you know I work here? This is my bike.
Okay.
So what did I do for you to approach me and then tell me that put my hands behind my back?
Sir.
What are you arresting me for?
I'm not arresting you. Right now, you're not cooperating with
For
me.
what?
And you're getting
You asked me
agitated.
no, you asked me for my ID.
Right.
I don't have to give you my ID
Okay.
unless I've done something. What have I done?
Turn around and put your hands behind your back.
For what? Are you arresting me? And for what
I'm
purpose?
detaining you.
Detaining me for what? Why are you detaining me?
You're not even listening.
What did I do for you to detain me?
Turn around and put your hands behind your back.
Was there a report that I stole something?
Yes.
There was a report that I stole something.
Turn around.
You just said, hold on.
Stop, stop.
The Supreme Court has long held that officers may acquire reasonable suspicion through an anonymous tip, so long as the tip provides enough information to justify a stop. In the 1983 Supreme Court case of Illinois versus Gates, the court held that a totality of the circumstances test must be applied to determine whether an anonymous tip is sufficiently reliable to provide probable cause to issue an arrest warrant. In the Gates case, the officers did not personally witness any criminal activity take place, but the court held that the anonymous tip in question was reliable because officers could verify several events predicted by the tip. 7 years later, the Supreme Court held that an anonymous tip was sufficiently reliable to provide reasonable suspicion so long as the tip accurately predicted several key details in the 1990 case of Alabama versus White. In the White case, the court explained that, quote, if an informant is shown to be right about some things, he is probably right about other facts that he has alleged, including the claim that the object of the tip is engaged in criminal activity. The Supreme Court has upheld this notion as recently as 2014 in the case of Navarrete versus California. All of these cases were based on the notion of an anonymous caller, and given that Mrs. Brunel was not anonymous and provided an accurate description of Mr. Domino and his actions, it is likely that the Clarkston officer did have reasonable suspicion to make contact contact with and identify Mr. Domino. All that said, Officer Lors made no effort to de-escalate the encounter or engage in a productive dialogue with Mr. Domino, and instead began accusing him of stealing and ordering him to comply. As Officer Lors reaches for Mr. Domino's hand, he resists, and a scuffle ensues, which results in Mr. Domino being tasered multiple times before eventually being subdued and placed into handcuffs. Once the officers place Mr. Domino into their patrol car, they search his bag and make contact with Mrs. Brunel.
Are you Jody?
Yeah.
Okay. Do you have your ID with you?
I do. I'm over here.
Okay.
I'm 214's mom.
Okay. Is that the male that you saw? Okay. Can you get me video? Male that came to this bike, everything that he did. He's an employee. We've got a witness that saw him going into cars, and we just fought and tased him. So
bike right there.
That bike, male come to it. Where did he walk? Which cars?
The car that he got into is clear on the other end.
Okay.
He kinda
So you
walked
saw one male walking from all the way over there,
clear over to here.
and that's the male that we talked to.
Yeah, I watched him.
Okay.
He got into 3 doors of that car, and then he just walked
Okay.
away and came clear over here. So
Okay.
I thought, well, that's not right.
Okay.
But
Okay.
the woman came
Can
over
you
and
start looking at that for me?
Get on it.
the
Thank
woman
you.
came over and was
Okay.
kind of pissed, saying it was his
On that
car is
jacket.
registered to him. But Jude, you say it's your car.
19's on scene with the RP.
And before he showed up, not one of you I know. I'm Brad Peters' mom.
Okay, I'm Chris.
Hi, Chris.
Just so you know, everything's being recorded.
Oh, okay. So,
So,
what did he say when you...
How many? He wouldn't say anything to me. How many cars did he look at?
Just the one. But
Just the one.
So that one car, far,
Like my pickup would
a
be
gray
parked.
Chevy Aveo, is registered to him, the same as the bike.
Okay. He could have.
Here, Officer Lors suggests that Mr. Domino could have explained his actions, but at no point during the initial encounter did Mr. Domino have enough information to know what actions led to him being contacted by the police. Although Officer Lors did say that Mr. Domino was reported for looking at cars, he also said that Mr. Domino was being accused of stealing, which likely confused Mr. Domino. Just 32 seconds passed from the point of initial contact to Officer Lors ordering Mr. Domino to place his hands behind his back. Officer Lors made no attempt to corroborate any of the information from the 911 call and shifted the focus of the stop to Mr. Domino's refusal to identify rather than the alleged crime. The state of Washington only requires officers to undergo 2 hours of de-escalation training per year. However, it is one of the few states that also requires supplementary training as well. There is no all-inclusive list that identifies all the methods and techniques officers might employ to de-escalate an incident. But earlier this year, the California Commission on Peace Officer Standards and Training created a de-escalation strategies and techniques manual that outlines several of the most fundamental principles of de-escalation and offers members of law enforcement thorough insight into how to de-escalate police interactions. One technique that the manual suggests is giving the suspect a voice by listening to their concerns, and the manual explicitly states that officers should seek first to understand before attempting to be understood. The manual also highlights the fact that there are many levels of control outside of physical control, and that while a lack of control can get an officer hurt, over-control, especially when not needed or justified, can cause hostility or draw a complaint. The manual goes on to state that physical control or force used for expediency, in most cases, should not be preferred over the use of skills and techniques of de-escalation that might otherwise take more time but achieve the same desired result. Officer Lors' immediate reaction to Mr. Domino's passive resistance was to gain control by force, which ultimately evolved into a physical altercation. At no point did Officer Lors make an attempt to understand Mr. Domino's perspective or offer him the opportunity to explain his actions. If Officer Lors had taken the time to give context to why he was contacting Mr. Domino, then this interaction likely would have had a different outcome.
Hey, Frim. So you saw him get into one car and then walk across
Yeah,
the
so
parking lot?
say like my pickup was right here. That car would have been right there facing me. So I put my cart away, and when he walked down this way, he walked to the passenger side, got in that door, came around this way, got in the driver's door, then got in the back. And there was a car right next to him, so he's holding his keys, but he never used a key on anything. It was all unlocked. And then I couldn't tell if he grabbed anything.
Okay.
But then he just walked away down this aisle and then just headed straight over here.
Okay.
So yeah, that looks like a prowl.
Right. Okay, let me get you a written statement form. If you could fill that out for me, I'd appreciate it.
You just wouldn't talk to him?
No, and then he started, like, he was just super agitated, I don't have to tell you my name. I'm like, listen, man, so right now you're being detained, and he got all jacked up, and so I'm like, okay, turn around and put your hands behind your back. I'm going to detain you. No. And then once Rabbit got here, he reached into his pocket real fast, and we went hands-on at that point and sort of danced around with him because he's a big dude like this for a while. And then finally he wrapped his arm around me, and I had my taser out already, and I tased him, and we took him down and finally got him cuffed, but we fought with him the whole time. So all he had to do was talk.
Officer Lures recounts his version of events as if Mr. Domino was the aggressor during the confrontation. But let's compare Officer Lures' recollection of the event to what actually happened.
He just wouldn't talk to you?
No, and then he started, like, he was just super agitated. You got ID on you?
Why do you need my ID?
And I'm like, listen, man, so right now you're being detained.
Did I do anything?
Yeah, I'm figuring that out right now. I'll take a look at your ID, though.
You don't need my ID unless I did something.
And he got all jacked up, and so I'm like, okay, turn around and put your hands behind your back. I'm going to detain you. Okay.
Unless you're taking me in for something like that.
Turn around and put your hands behind your back right now.
For
now.
What? For what?
Turn around and put your hands behind your back now. You're going to obey me, or you're going to go on the ground.
Why obey you?
As you can see, there is a vast discrepancy between Officer Lures' version of events and what actually took place. It is no secret that officers sometimes lie when reconstructing interactions on police reports, and their motivations for doing so are obvious. Dr. Philip Stinson, who is an ex-police officer and now professor of criminal justice at Bowling Green State University in Ohio, has tracked arrest cases of non-federal sworn law enforcement officers who have been charged with at least one crime from 2005 to 2014. Dr. Stinson has compiled an extensive catalog of studies that examine various aspects of policing, and was recently named the principal investigator on a research project funded by a grant from the National Institute of Justice to study police crime across the United States. His research shows that out of more than 10,000 officer arrest cases, about 6.3% involved false reports or statements. And he recently told CNN that the problem is probably more common than the data suggests. There are a litany of reasons why an officer may choose to lie about their interactions, such as fear of losing their job, or what is known as noble cause corruption, which is the idea that the ends justify the means, and lying to secure an arrest ultimately makes their communities safer. There are repercussions for officers who lie on their police reports, particularly when those reports are submitted as evidence in a trial. Washington Code 9A.72.020 states that a person is guilty of perjury in the first degree if in any official proceeding he or she makes a materially false statement which he or she knows to be false under an oath required or authorized by law. And officers who testify that their report is accurate and are proven to be lying can face prosecution under this code. Officer perjury is often difficult to prove without irrefutable evidence, and even in the cases where it is proven, securing a conviction can be challenging, given that prosecutors often work closely with police officers in their community. There is no doubt that Officer Lures exaggerated the circumstances surrounding Mr. Domino's detention to the other officer, and the other officer states that Mr. Domino could have provided a simple explanation and resolved the issue.
Yeah, if you would have said that's my car, it could have been done in 2 seconds.
Okay. You can just fill this out and drop it off at PD.
Okay.
Or have Brad drop it off for us, whatever works for you.
Okay.
As soon as you can. I'm not sure yet.
So what did he say when...
He wouldn't say anything. I don't know anything, so still get everything figured out. Yeah, me too. Thank you.
Mr. Domino was arrested and charged with resisting arrest and obstructing a law enforcement officer, and was released a few hours later. Following the encounter, Clarkston Police Chief Joel Hastings publicly stated that an internal investigation would be conducted to determine if there was any wrongdoing, as the department always conducts an internal review anytime force is used. After multiple hearings, the trial began in November of 2019, with Mr. Domino deciding to represent himself. After 2 days in the courtroom, Mr. Domino verbally agreed to a plea deal offered by the prosecution, which stipulated that so long as Mr. Domino stayed out of trouble for the following 3 months, all charges against him would be dropped. Mr. Domino told the Lewiston Tribune that he had no intentions of suing the department and agreed to talk to the Clarkston Police Department about how the situation could have been better handled. Mr. Domino later rejected the deal offered by the prosecution and decided to move forward with the case, along with filing a $5 million tort claim against the city. Overall, Officer Lures gets an F for failing to employ any measure of de-escalation during the encounter, neglecting to conduct a thorough investigation, and for misrepresenting the circumstances surrounding Mr. Domino's arrest to his fellow officer. Officer Lors made no legitimate effort to find out what happened before accusing Mr. Domino of committing a crime. And although it could be argued that he did have the reasonable suspicion necessary to detain Mr. Domino, there were a plethora of resources available to ensure that he was apprehending the right suspect for the right reasons. While officers are afforded a considerable degree of discrepancy to perform their duties, this interaction is a prime example of an officer wielding that discrepancy recklessly and performing their duties in a way that restores peace at the expense of equitable justice. Much of the outcome of this interaction can be directly attributed to the officer's lack of de-escalation and preference for forceful control. If Officer Lors had taken the time to thoroughly explain the situation to Mr. Domino and conduct a comprehensive investigation into the complaint, then this interaction would likely have resulted in proving Mr. Domino's innocence rather than escalating into a physical altercation. Once Officer Lors discovered that the vehicle in question was registered to Mr. Domino, he attempted to downplay his own aggression and shifted the blame to Mr. Domino's lack of compliance. If Officer Lors had simply walked over to the vehicle to see who it was registered to before demanding identification from Mr. Domino, the escalation could have been avoided. Officers who employ physical force well before exhausting any other means available to them do a disservice to their community. And Officer Lors' actions, while not necessarily illegal, did nothing to contribute to the safety of his community. Mr. Domino gets a B-, because although he did physically resist the officers, he made an attempt to exercise his rights and refuted the criminal case against him by himself with no formal legal training. It is difficult to fault Mr. Domino for his initial resistance to Officer Lors, but Mr. Domino continued to physically resist the officers well after backup had arrived and his arrest was inevitable. While it is likely true that anyone in his situation would have behaved similarly, that does not excuse his actions entirely. And as mentioned many times on this channel, there is nothing to gain from resisting an officer, even if you believe the arrest to be unlawful. I commend Mr. Domino for having the courage and discipline to represent himself in court, and for volunteering to speak with the department in an effort to ensure that this does not happen to anyone else. The hearings for Mr. Domino's case have taken place over several months, where he has filed multiple motions for dismissal, but each one has been rejected. As mentioned before, his case will now be moving to a jury trial, where Mr. Domino intends to continue representing himself. At Mr. Domino's latest court appearance on August 26th, a crowd of protesters formed outside of the Assateague County Courthouse, demanding that the charges against Mr. Domino be dropped. Mr. Domino's trial is set to begin on October 8th. Let us know if there's an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to like and subscribe for more police interaction content.
A cavity search on a female arrestee. She was clearly uncomfortable.
Can I
Darby?
test it real fast and then you can
Darby.
Has she been drinking?
Absolutely.
I can smell it.
Did you go deep? Darby.
Not?
Come on. Darby. You're allowed. Just get that finger there.
Just after well, I'll drop it.
Finish the conversation, Darby.
Okay.
You gotta go in there. You're gonna have to transport her, Darby. Darby, you're my everything.
Thankfully, she complained, but this was not his first time.
Life's a lot like a wiener. Sometimes it gets hard for no reason.
And you, what? No.
Okay.
I noticed a news report from Tennessee stating that a police officer with the Rockwood Police Department had been fired.
Police officer in Rockwood was terminated following his actions during a traffic stop last year. That termination was appealed, but City Council upheld it in January.
Now, we do want to warn you, some of the details in this story may be offensive to some.
I decided to FOIA the body cam footage and his personnel file to see for myself. What I learned is that this guy shouldn't have ever been hired in the first place and shouldn't be allowed to pop up anywhere else, and I'll show you the reason. This is the actual body cam footage that resulted in his getting fired. The incident began with a November 13th, 2025 traffic stop in Harriman, Tennessee. Charles Hobrick was working as an officer with the Rockwood Police Department. Also on scene were officers from the Harriman Police Department. Harriman Police Department. Best as I can tell, this woman allegedly hit her ex-boyfriend's new girlfriend with the side view mirror of her car while driving down his street, which she was not supposed to be driving down. And that was reported, and the Harriman Police Department then stopped her for speeding in their town. Meanwhile, Officer Charles Hobrick, who is an officer with the Rockwood Police Department nearby where that alleged collision occurred, he arrives at the scene and he confronts the woman.
Hey, get her out. Hey, take her out. I need her out. Step out for me.
I was trying to have a conversation with Derek because I've known both of them since we were.
Step back here. She has a picture of you, she has a video of you hitting her arm.
No.
With your car.
No.
So what happened?
No. I pulled up and she pushed the thing in my mirror. I left it purposely in because she purposely pushed it in. I didn't hit anyone near.
How much you been drinking?
I haven't been drinking.
Hey, right here, listen to me. I got a dog. Dog alerts on 5 odors. Listen. Marijuana, methamphetamine, heroin, cocaine, and ecstasy. So what it is, I'm gonna walk the dog around the car. All right?
I'll give it to you. I have legally purchased pre-rolls from the store to help with my migraine, so I don't have to take all my.
And now listen to me. Those pre-rolls, once you light them, it changes the THC content to become illegal. All right? So what it is, if the dog alerts on odor, then that gives us probable cause to search.
I understand, sir, but I live in my car, so like when I don't have a place to stay, like.
I understand. Just wait here, and I'm gonna take the dog around it.
He questions her for a few moments, and then he gets his dog out of the car to sniff around the woman's car for drugs.
That's a good boy. Yeah, brav. Doopsiek. Ja, doopsiek. 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 So he takes the dog around the car, instructing the dog basically to alert in several spots, which not surprisingly the dog does. Canine deployment. Hey, boy. Boy. Topsiek. Zoek. Hey. Topsiek. Check up. Hey. Check up. Zoek. 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 Kom hier. Hey. Zoek. Kom hier. Zoek. Zoek. Hey. Zoek. Zoek. Check up. Sneer. Zoek. Zoek. Hey. Topsiek. Sniff. Sniff. Zoek. Central 213. Positive alert. And then he goes and he puts the dog back in the patrol car. He puts on his gloves and he begins to search the woman's car. We got it. What's in the car? Anything illegal?
It's just my pre-rolls. That's all that's in there. I can give them all to you.
Well, I'm going to give you some DUI here in a minute because I can smell alcohol too. Eventually, Hobrick tells one of the other officers to continue searching the woman's car while he begins to investigate the woman for DUI. I'm going to let you search this, and then I'm going to fucking do DUI on her. It's field sobriety, if you don't mind.
Yeah, you're good.
All right.
I'll give them, like, I think there's only like 1.5 pre-rolls in there. That's all I've got.
Here's what I'm going to do. I'm going to pull my car in front, and then I'm going to give her some field sobriety. Officer Hobrick then does some field sobriety tests, though he hardly bothers to point the evidence-gathering machine mounted on his chest at what the lady's doing, so we can't really judge her performance. Stay right there in front of my car. Do you know what day it is?
Okay.
I have a labral tear in both my hips, chronic migraines and spots in my brain that cause a gait to
Leave the glasses on the hook for me.
I'm sorry, it's the brightness.
I understand.
It makes me sick.
See my finger?
Yes, sir.
It's the tip of my finger.
Yes, sir.
All right. I need you to follow the tip of my finger with just your eyes. Put your foot back on the line. Take 9 heel-to-toe steps back.
But in any event, this video is not about the DUI, whether or not she was actually DUI. I don't know what ever happened about that, but it's about what happened, or it's about the circumstances that occurred as she's being arrested. So here's what happened. She's being arrested after the woman is handcuffed. A female officer with the Harriman Police Department begins begins to search the woman prior. After the woman is handcuffed, a female officer with the Harriman Police Department begins to search the woman prior to placing her in the police car.
At this time, I am placing you under arrest for DUI, vehicular assault. All right. And if the Harriman has any charges, they're going to charge you. All right. Now, are you willing to give me a sample of blood? Central 213.
That's Anthony Tucker.
Did you get the 28 off this vehicle from Harriman? 10-4. Thank you, ma'am. Just make sure that's added to the card. Did you find it?
Policy.
After she finishes, Hobrick says to the female officer, "Did you go deep?"
She got in there?
Not that I can.
It's against our policy.
Did you go deep?
Can I
Darby.
adjust it real fast and then you can
Darby.
Have you been drinking?
Absolutely.
I can smell it.
Did you go deep? Darby.
Not?
Come on. Darby. You're allowed. Just get that finger there.
Hobrick then laughs at what he said, while the female officer is sort of visibly uncomfortable with the conversation. The officers then have an extended conversation with the arrestee, where they basically debate issues of constitutional law as well as the level of her alleged sobriety.
Just so you know, the pre-roll stuff, once you light it, you're burning it. It changes the THC content, it goes up, it becomes illegal. Okay? That is a fact. My dog is proofed off of hemp and marijuana. So if he alerted on your car, which he did, that means it is illegal marijuana.
But it's a totality of circumstances.
No, it's not a totality of
I
circumstances.
mean, that's what Tennessee awarded back in like August of last year, but okay.
Awarded what?
That it was a totality of circumstances.
What's a totality?
Because hemp and marijuana smell the same, and I legally purchased it
All right, listen
over the
to,
counter.
listen to what I'm telling you.
I legally purchased it
Yes,
over the counter.
but this animal here has been proofed. There is 26 molecules in hemp. 13 of them are shared by marijuana, but there are 2 volatile odors that the THC has that the hemp does not. That animal alerted on that car. That means it's THC, not hemp.
Okay, but the Tennessee Supreme Court ruled in what, August of 2023, I believe it was, that it's the totality of circumstances.
True, but there's a case study that came out.
That's fine.
I'm just letting you know.
I legally purchased it. I don't have anything
It's legal until you burn it.
It's legal until you burn it.
Okay.
Yeah, and when you're
behind
when you're DUI.
But you smoked it and got behind the wheel.
If it's in your system and you're driving, well, it stays in your system for several days. So, I mean, that's a catch-22. Come on now.
After which the female officer sort of gets frustrated and she begins to walk away. As she's walking away, Officer Charles Hobrick again begins to restart the prior conversational tone that he had with this female officer. Clearly, that was making her uncomfortable.
There's a difference, though, in it being in your system for several days.
Darby, you got to talk to her, Darby. Darby, come on. Finish the conversation, Darby. You got to go in there. You're going to have to transport her, Darby. Nicole.
Smoking and driving.
Nicole.
I wasn't doing any of
Listen
that.
to me.
So,
Nicole.
that's fine.
No, did it?
Then it appears from the direction that his body cam was pointing that he was just sort of staring at this female officer for no reason for an extended period of time, rather than towards the arrestee, who was still over there making statements at that point. The female officer does appear to me to be uncomfortable.
It's Eric's vengeance.
It is.
He starts to talk to her again, telling her things that she already knew.
The mirror.
She knocked the mirror, and what it was, she came up. She was on North.
Melinda hit the mirror.
She came up. The good lady said she stopped right behind her. And then what it is, she swerved around her, and when she did, she hit her in the arm with the passenger side.
So she begins to walk away from him. As she's walking away, he asks her why she's going home so early.
If you're going home, why are you going home so early? It's fun. Go.
I mean, it is. Who's taking her?
She is.
Then as she's finally walking away for good to leave, walking towards her cruiser, Charles Hobrick once again calls her name, and he says, "You're my everything."
Darby, you're my everything.
She doesn't respond. She doesn't even turn around. She just continues to walk away. And this wasn't the first time that he had talked to women this way while on the job. Here's a clip of something that Officer Hobrick said to a woman at a traffic stop over a broken headlight.
Life's a lot like a wiener. Sometimes it gets hard for no reason.
And you, what? No.
Okay.
In fact, according to the local news, Hobrick has an extensive history of similar complaints.
Reprimand after reprimand, written warning after written warning. The personnel file for former Rockwood police officer Charles Hobrick is chock full of them. We sifted through more than 100 pages from multiple police departments. Hobrick began working for Rockwood Police in 2007. Earlier that year, he worked for Graysville Police Department for 6 months. There, according to his personnel file and an article from the Herald News in Graysville in 2007, a father filed a complaint against him alleging that Hobrick told his 17-year-old daughter to get in the squad car to talk alone. Hobrick was suspended following this complaint in September of 2007 and ultimately resigned a month later. Shortly after, in November of 2007, Hobrick began his career with Rockwood Police. He got a few violations in 2013, but the bulk of written warnings and reprimands we saw began in 2020. Those reprimands were for conduct unbecoming of an officer, for sharing an offensive Facebook post, and the second, making comments about women's weight in the 911 dispatch center, going as far as asking a dispatcher if she is pregnant, but after all of that, he was able to keep his job.
According to the personnel file information I received from the Rockwood Police Department, Officer Charles Hobrick was formally notified in November of last year that he was being disciplined for this incident. Specifically, he was told, on November 13th, 2025, at a traffic stop in Harriman, you repeatedly asked a Harriman female police officer if she had performed a body cavity search on a female suspect in the presence of that female suspect, and incorrectly informed the female police officer in the presence of that female suspect that she had the right to perform a body cavity search, although no search warrant had been issued. You referred to the body cavity search as going deep. He was given the opportunity to respond as well as a hearing on these disciplinary charges, and the documents indicate that on November 21st, there was a meeting that took place where the incident was discussed with the chief of police as well as Hobrick's direct supervisor, his lieutenant. The meeting notes indicate that Officer Hobrick acknowledged the complaint but stated he couldn't control how another officer interpreted his remarks. He expressed willingness to apologize and maintained that he didn't violate policy or suggest anything illegal. He clarified that his comment referred to a person, quote, stuffing dope in her bra, but the chief of police responded that it didn't appear to him that the comment referred to a bra and emphasized that the statement was unprofessional and inappropriate regardless of intent. Finally, the documents indicate that on November 25th of 2025, it was formally determined that Hobrick's conduct violated Rockwood Municipal Code as well as the department policy in a number of ways. The document also says that Hobrick had been previously suspended on May 30th of 2025 for failing to maintain a city-issued canine in a safe and controlled manner in a local auto parts store.
That's a good boy. Yeah, brave.
As well as 2 reprimands in his personnel file for making disparaging and inappropriate comments to female staff members at the Brown County 911 office, noting that past efforts to rehabilitate you have not been successful. Ultimately, based on these things, he was terminated. He is apparently appealing. Clearly, Officer Habrick has been acting like a creepy guy for a long period of time. It's too bad that something wasn't done sooner. This guy had been there since 2007. That's almost 20 years of likely acting this way. And good for the female officer for finally complaining and getting him fired. It's probably happened to countless women that he's arrested, such as this woman.
Life's a lot like a wiener. Sometimes it gets hard for no reason.
And you, what? No.
Okay.
It's crazy that he's acting this way now in 2026, knowing full well that he's being recorded on body cam. But you can help make sure that he's not given a badge anywhere else by spreading this footage. Put it in front of as many eyes as possible.
You're allowed. Just get that finger there.
If I hear anything else, I'll update, and you can follow along by subscribing both here and at the blog at thecivilrightslawyer.com. You can follow me on X at JohnBryanESQ. Remember, our rights don't end with accountability, but let me give you a good story. Back on March 17th, if you saw the live video I did with Kentucky attorney Chris Wiest, he showed us a video of an excessive force case that he's litigating in the federal courts in Kentucky that showed clearly force being used by a police officer, and clearly excessive force being used. And then he showed us videos from the depositions of the two officers involved where they denied that any force was used. And we sort of joked around about it at the time. It's a great video. If you haven't watched it, check it out. And really like to do some more with him as well. But he just texted me here a few days ago, I think it was on Friday, and says, you know what? They just criminally charged that officer for perjury. And you know, in my probably 15 years of litigating police cases, I can probably count on one hand the number of times I've seen anyone charged with perjury, especially police officers. I have seen it happen before, and this is apparently one of the few instances. But first, if you don't recall the footage, check out the video. This is actually surveillance footage from the Hornback home in Kentucky. And you see two police officers come in, and they're led by Mr. Hornback's father to where their son is. I guess there's a warrant out for him. And then, really within seconds, you see them begin to use force. They put him up against the wall and pretty much immediately take him down without any indication that he was fighting with them or attempted to strike them. And look, you see some punches, you see some hits. Clearly force is being used. I mean, that's undisputed, right? I mean, we can all agree that we see force being used on this video. Now, Mr. Hornback's father then leaves the room as this is going on, and he goes and he gets his cell phone, and you'll see that he returns with his cell phone. Now, this is, again, surveillance footage that belonged to the family. And it's fortunate that they did that because, again, you'll see that he returns with his cell phone, but when he comes back, he starts to, I mean, it's a little late, but even though it's a little late and he starts to film it, I believe they ended up deleting that footage. So they didn't know, they weren't aware that there was this surveillance footage in existence, and that's important here. So they didn't know the footage existed. And the next thing that happened was attorney Chris Wiest filed a federal civil rights lawsuit for excessive force and served it on them and started the litigation process. And usually you have to turn over all of your evidence before you end up taking depositions. But through basically brilliant strategy, he ended up getting to take their depositions before he had to turn over his evidence. And so that made for the interesting situation where he got to question these police officers under oath about what they did not do, and they still weren't yet aware of this video. And that's really an awesome situation that is very difficult to set up in federal court. And I encourage you to watch the conversation that we had about this in that earlier video that I'll post the link in the description. But he provided us with the deposition footage where they were asked about this. So here is I believe this is the deposition of Thomas Zartorsky, who was one of the officers involved in this.
No, I understand, and I'm just trying to get to your recollection. You indicated that you don't remember whether or not he was taken to the ground, right?
So I think that he was taken to the ground.
Do you know why?
I don't.
Okay. When he was taken to the ground, did you use any force on him?
No.
Did you ever strike him with any object?
No.
So that was the deposition footage showing Trooper Zartorsky. And here is the deposition footage, or at least a small portion of it, of the other trooper, James Cameron Wright. And you can hear Chris Weiss just setting this up beautifully so that he can knock it out of the park afterwards.
You wouldn't have to, but I'm not saying I did that.
Once you had him on the ground, did you strike or hit him with a closed fist at all?
No, sir.
Okay. Or any part of your body?
No, sir.
Okay. And the reason that you didn't do that is that there was no more force that was required at that point in time to have affected the arrest, right?
He did not need to be struck with my hands or any impact weapon, and also his mother.
So let's take a look at that again. Did you strike him with a closed fist or with your hands? I believe that is right there, striking him. He's on the right. Striking him with his hands. We clearly just saw it. And let's look at Zartorsky again. Okay, as you sit here today, is it your testimony that at no time did you strike him with an object? No. That's correct, right? At no time did you strike him with an object? No. Yet there he was, on the left-hand side, striking him with an object. Well, maybe that's just not an object he's hitting him with. What else could it be? Well, it could be a thought, maybe. Maybe he's hitting him with a thought. And now for the good news, this link that Chris had sent me from the Kentucky Center for Investigative Reporting, July 9th, 2021. This former Kentucky trooper denied using force under oath. The video says he did. A former Kentucky state trooper has been criminally charged with perjury after denying under oath that he beat a man with a flashlight in April 2020. Now, I'll post a link to this story here in the description. Thomas Zartorsky was named in a lawsuit alleging troopers used excessive force against Alex Hornback while executing a bench warrant. The lawsuit also alleged that Hornback's parents recorded the officers beating him and that a trooper deleted the footage, but a home security video captured the incident. Okay, so he was caught in a lie. He was caught in a lie, and it appears that there has been accountability. So apparently he's been fired as well. Zartorsky was deposed under oath in January for Hornback's federal civil suit. Hornback's attorney, Chris Weiss, asked if he'd struck him with an object or used any other force. No, he said, I did not use force on him. The video shows that Zartorsky and Trooper James Cameron Wright meet Hornback in the family's basement. Hornback puts his hands on the wall, then within seconds, Wright forces him to the floor. Wright punched him with a closed fist. And remember, we see Wright doing it on the video. I mean, who are you going to believe? Me or your lying eyes? We see it happening on the video, and yet we also hear him under oath saying that he did not do it. And I'm not sure if he was charged. Maybe the article gets to that. All right. Wright punched him with a closed fist. Zartorsky beat his legs 4 times with a flashlight. But a flashlight may not be an object. It could be like one of those Bill Clinton things. Like Bill Clinton might not believe that a flashlight is an object. It could just be something else, like maybe a thing. Wright then held Hornback on the floor for about 30 seconds with his left knee on the back of his neck. Okay, Hornback appeared compliant throughout the encounter. That's absolutely true, according to what I observed. All right, more good stuff. court records show that the Kentucky State Police Internal Affairs Department investigated Czartoryski for 2 incidents where he used force in the month before Hornbeck's arrest. And if you watch the video where Chris and I are discussing this, he actually shows us those other videos. And you can kind of see, since Czartoryski was the one using the sort of, I don't want to say maybe non-masculine kind of hit. You see the exact same sort of technique being used in these other beating videos. Maybe that played a role in why they were willing to hold him accountable here. I don't know. In one incident, he kicked the suspect's lower body while he was on the ground, and numerous other officers had gained control of him. In the second, a week prior to Hornbeck's arrest, he struck a man with a flashlight 8 times. Certainly, he didn't strike him with an object. He struck him with a thing or a flashlight 8 times after Wright pulled him from the car during a traffic stop. Usually where there's smoke, there's fire. Not always. Including one strike that investigators said came as the man was trying to stand up and comply. Now, good for investigators in Kentucky. Investigators found 2 violations, conduct unbecoming and excessive use of force, and suspended Czartoryski. Now, that was in the earlier case. Despite the fact that he testified under oath just 2 months later, Czartoryski said in his sworn statement that he didn't recall the suspension. Now, I believe he's been fired as well. I'll have to ask Chris about this, and maybe he'll come on and explain more. But what happened with the other guy? I mean, clearly he lied. I don't see why Czartoryski's lie was any worse than Wright's lie, except for, Czartoryski had these other incidents caught on video. So, can this officer that was charged get qualified immunity? No, he can't. You know why? Because these are criminal charges. Qualified immunity does not apply as a defense to allegations of criminal conduct, or at least in a criminal case. So that's not a defense there. Now, he could assert it in the federal civil rights lawsuit. Now, but he's not charged with perjury there. That's not what's alleged, though that will be an extremely useful fact that is true. He's charged with excessive force. So what's important in an excessive force case? So this is not a pretrial detainee. It's basically somebody who's being arrested who's not already in custody. You look at the basic gram factors. Was this a dangerous person? What was he under arrest for? Was he actively resisting arrest or fighting with the officers? So the video basically, I believe, in my opinion, will seal this up, as we had discussed with Chris before. It shows that he's not actively resisting or fighting the officers, and in fact appears to be cooperative or compliant. Now, sometimes officers in those situations will say, well, yeah, what the video doesn't show is that he was tensing up or something like that. But, the video shows what it shows, and it shows 2-on-1, a man who is presumed innocent. He's in his own home. His parents are watching. He undisputedly does not strike at, does not try to kick, does not try to punch any of the officers. It doesn't appear he tried to spit on them or anything like that. Now, he may have been saying something. A lot of times in these videos, they're running their mouths. But, basically you can just about say what you want. You can say what you want, and generally mere words alone are not sufficient to warrant this sort of a violent response. So, I mean, I've had cases where there's all sorts of awful things being said, but you're not allowed as a police officer to lose your temper and violently attack a person in response to any words that he said. So it has to do with a basic self-defense sort of analysis. Did he pose a threat to these officers or anyone else? And if they thought he posed a threat, then why is that? Was it because of his criminal history, or the alleged crime that they were arresting him for, or based on something that happened at the scene? So it's undisputed what they were arresting him for. It's undisputed what his criminal history was. I don't even know all that, but and it's undisputed really what happened, almost undisputed, because it's caught on video. There's a U.S. Supreme Court case, Scott versus Harris, that says if law enforcement testimony clearly contradicts what's seen on the video, the court is allowed to go with what's on the video because it's, they didn't say this, but it's, more credible than self-serving testimony from a police officer who's been alleged to have committed misconduct. And clearly that has been illustrated in this case where both of these officers lied when they said that they didn't use force. And this has nothing to do with systematic racism, as you can see. Everyone appears to be the same race. This is a problem that's been around for a long time and transcends race, ethnicity, nationality. And it has to do with just living in the current police state, that we've chosen to create for ourselves, where, how many times have they gotten away with it? And they've been able to lie about it. And, fortunately here we have a rare case of accountability because there was a lawyer who stepped in and forced the issue and did it in a really clever way so as to sort of kill two birds with one stone, so to speak. And I'm not just talking about the officers, but while he's proving excessive force, also proving that these guys are liars and are committing perjury. So good on the Kentucky investigators for at least taking action against this one guy. And I'm not sure about Wright, the other one. I'll have to ask Chris about that. But he's on video doing the same thing. So we'll have to have an update hopefully in the near future on this.
Charged with possession of a controlled substance, assault, resisting arrest, and obstructing police, as well as a traffic violation. A day earlier, Haley was pulled over for failing to use a turn signal, but he fled the scene and headed home. When police caught up with him later that night, they found him in possession of a controlled substance. He was arrested and charged. Today, he appears before Judge Elizabeth DeSanto to hear if he'll be granted bond. The defense attorney is John Goldpaul, who enters a plea on his client's behalf.
We'd ask that the plea of not guilty be entered on his behalf.
Yes, to bond counsel.
Your Honor, Mr. Haley is 56 years old. He does have a prior criminal record. He did have a felony drug case back in the 90s. At no time has he ever failed to appear. He's not on probation or parole at this time. We'd ask for a personal bond in this particular matter. Mr. Haley knows the consequences of not appearing, and I'm sure that he will be appearing in court.
When was the last time you were employed, sir?
2002, 2004.
And so how have you been supporting yourself since then for the last 17 to 19 years?
Bingo.
I'm sorry?
Bingo. I'm a professional bingo player. Yes, ma'am. I play bingo.
Okay, well, that's the first. I have not heard of a professional bingo player. How much does one make being a professional bingo player?
Oh, it varies. If I just chase big jackpots and progressive games all over the state.
So for the last 17 to 19 years, you've been strictly working as a professional bingo player.
Pretty much.
The judge wraps up the bingo conversation and inquires further about Haley's criminal history.
So tell me about your felony assault charge out of Detroit in 2012.
You mean? I don't really recall that.
All right, what about 2015 out of Detroit, felony assault?
Ma'am, I don't know anything about it.
You were never charged with that?
Your Honor, I recently was acquitted of a charge. I cannot remember the exact year. I was acquitted of all charges. And I have not been in prison in anybody's jail since 1994.
Okay. Well, in 2020, there is a warrant, 4 counts of felony firearm, dangerous weapon, carry and conceal. Do you know anything about that?
That is not me. 2020, oh no.
Haley may have foggy memories about his earlier legal problems, but it turns out he's correct about the gun charges from 2020. Records show that Arthur Haley is 22 years younger than this one. In any case, Judge DeSanto decides to move on to Haley's most recent charges.
All right, well, here's what I'm going to do. I'm going to indicate a $5,000 10% bond, not to possess and consume the alcohol or drug unless prescribed. If you're tested today, what would be detected in your system?
Probably just a glass of wine.
A glass of wine? Okay.
Last night, yeah, that's about it.
Okay. All right, so 5,000, 10% bond. We'll see you back next week.
Haley posted bond, and his case is pending.
Anything else you wish to tell me, sir, regarding your bail? This conversation could endanger my life, your life, this guy's life, any officer in here's life.
Next, we go to an arraignment in Allegan County, Michigan. The defendant is 32-year-old Joshua Dimstra. He's been charged with possession of methamphetamine. This is Dimstra's second drug offense. If convicted, he could be looking at 20 years in prison. The judge today is Joseph Scotchless.
Are you Joshua Dimstra? Yes, I am Joshua Kevin Dimstra.
Getting things started is the defense attorney, Dario Sierra.
Your Honor, I attempted to have a conversation with Mr. Dimstra in regards to these charges. Unable to have a meaningful conversation, I'd ask the court to arraign him at this time.
With the defendant and the attorney not appearing to be on the same page, the judge continues the hearing on his own.
Because of that prior drug conviction, they have charged you as a repeat offender. As such, this is a felony charge. Maximum penalty is 20 years in the state prison and/or a $30,000 fine.
The judge goes on to explain the defendant's rights before offering Dimstra a chance to speak.
Anything else you wish to tell me, sir, regarding your bail? I'm not going to take the blame or plead guilty to something that isn't mine. I mean, you're not going to work for Homeland Security and then try to come at me. I work for Homeland Security teams and other courts and stuff like that, and for the law and military and U.S. Supreme Court, and make it seem like I'm the bad guy, because I'm not. This guy here, Dario Sierra, he says that I wasn't compliant on the phone this afternoon. That's a lie. I've been very kind. I've been very respectful. I refuse to be a criminal. I am not a criminal. I am professional, just in a different way. I am me. I'm for the courts, for law, and above, also all military and above military. I already talked with a lot of important people that work for the government and federal government.
While the judge and defense attorney listen patiently, Dimstra wraps up by claiming that his drug charge is the result of him being an undercover agent.
I am 100% undercover, and I've been working on other cases to investigate, to get in close for SWAT, for CIA, FBI, DEA. This is not an illusion. I have witnesses. I have the state. I have other states. I have governors. I have mayors that are on my side. This conversation could endanger my life, your life, this guy's life.
Over 8 minutes later, Dimstra finally wraps up.
Whatever it takes to help you understand that, I hope my words did. And that's the God honest truth, so.
The undercover claims proved to be false, and the judge sets Dimstra's bond at $1,000.
Condition of bail is you not possess or consume any alcohol, marijuana, or controlled substances. The public defender's office is being appointed to represent you in this case. But with that, you're all set today. Good luck to you, sir. Also, could I say one more thing? Thank you, sir. You're welcome.
Dimstra has yet to enter a plea and remains in jail. The results of his case are pending.
I'm dealing with the wolves. There's no fair trial in this military maritime courts.
Next, we're at a virtual arraignment hearing in Lenawee County, Michigan. 5 months earlier, defendant Robert Joseph Matson was pulled over for a traffic violation. Officers found cocaine and an open alcohol container. Mattson was also charged with operating a vehicle on a suspended license.
All right, we are on the record then in the matter of the people of the state of Michigan versus Robert Joseph Mattson. Sir, you are Robert Joseph Mattson, correct?
I am an attorney for the all caps name Robert Joseph Mattson. I am living flesh and blood, human. Upper and lowercase, Robert hyphen Joseph space Mattson.
Mattson identifies as a sovereign citizen and believes certain laws don't apply to him. Public Defender James Daly was appointed standby attorney at an earlier hearing, but Mattson wants to represent himself.
I never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
I was appointed as standby, Your Honor. Mr. Mattson and I, we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
It is Mattson's right to represent himself, but Judge Michael Olsaver must make sure he fully understands the consequences of that decision.
I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself without a licensed attorney on the other side.
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts.
Do you have any hesitation about the fact that you want to represent yourself?
Nope. No matter what you do to me, I will get out of it, and there will be lawsuits.
The judge moves on and ends the hearing by entering a not guilty plea on Mattson's behalf, since he refuses to enter a plea on his own. Mattson was already being held on $50,000 bond for failing to appear at an earlier hearing, so he remains in jail. A month later, at a pretrial conference, he's seemingly had a change of attitude.
James Daly on behalf of the defendant.
Mattson ditches his do-it-yourself approach and allows Daly to represent him. And that's not all he's changed his mind about.
And it's my understanding that a plea agreement has been reached.
Yes, Your Honor. It's my understanding Mr. Mattson will be pleading to count 4 attempted possession of amphetamine on the amended information that was sent to both the court and defense today.
All right, Mr. Daly, is that your understanding of the plea agreement as well?
It is, Your Honor, along with the fact that Mr. Mattson would be released from custody today.
It's not part of the plea agreement, but it is something after the plea that I would have no objection to.
Mattson has a lawyer, a plea deal, and he's getting out of jail until his sentencing. Plus, his bond is being reduced to a no-fee personal recognizance bond. Judge Olsaver is ready to move on to the plea deal.
Mr. Mattson, would you raise your right hand, please?
If I'm not going to get out today, there's no deal. We got trial Friday. I'm just going to trial. I want to make sure that I'm going to be released, so I'm not going to take the plea today.
That's not what I said, Mr. Mattson. I did say I'm agreeing to a bond reduction today, but that is separate and not contingent on the plea.
For release. Trial Friday. That's it.
Mattson doesn't realize he's getting out. He rejects the plea deal and demands a trial instead.
Mr. Mattson, there is an agreement to a bond reduction today, so...
It's a PR bond, correct?
Yes.
Okay.
Now that that's cleared up, the judge proceeds, again, with Mattson's plea.
Mr. Mattson, is it your intention to plead guilty today to count 4 on the amended information, which is attempted controlled substance, but attempted possession of cocaine, heroin, or another narcotic of less than 25 grams?
Under duress, yes.
All right, I'm not going to take a plea that is on the record stated as being under.
Your Honor.
Mattson seems bent on undoing his new plea deal. Defendants must enter these agreements of their own free will, no coercion or duress. Public Defender Daly looks exhausted. Mattson reconsiders and drops his duress claim.
So you want to move forward with your plea now?
Yeah.
How do you wish to plead then to the charge that's attempted possession of cocaine, heroin, or another narcotic of less than 25 grams?
Guilty.
Finally, Mattson makes good on his plea deal and is found guilty on the lesser drug charge. He's free on bond, awaiting sentencing.
Good afternoon. What is your name?
Philip Conklin.
Next, we're in Ypsilanti, Michigan for an arraignment. 35-year-old Philip Conklin has been charged with arson and assault with intent to commit murder. A day earlier, according to police, Conklin was staying at his sister's house where he was supposed to be babysitting her 4 young kids. But instead, the defendant allegedly set fire to the home with the children still inside. Neighbors called the fire department, who quickly extinguished the blaze. None of the children were hurt. Conklin was arrested and officially charged, and today he appears before Judge Tamara Garwood to hear if he'll make bond.
Count 1 alleges that you did make an assault upon the intent to commit the crime of murder. Do you understand this first charge?
No, I don't.
Okay, so I'm not asking if you agree or if you disagree with the charge. I'm asking if you understand that's what you've been charged with.
No, I don't. Understand.
You don't understand?
Nope.
Okay, so then we will go through that word by word. It alleges that you did that with intent, that you were going to accomplish the crime of murder. Do you understand that?
No, I don't. You guys are ridiculous.
Sir, do you understand what the charge is? Not do you agree with it, but do you understand what she
Sure,
said?
I do. Yeah, you guys are out of your minds, though.
So the maximum penalty for that charge, it's a felony. It's life or any number of years. So do you understand that maximum penalty?
Yes.
After reviewing the arson charge, the judge asked prosecutor Jessica Blanche for the state's bond recommendation.
We're asking for a $50,000 surety bond in this case. The defendant allegedly took gasoline, poured it all over a house that housed children, and said he was going to burn the house down. The door was locked to where the children were. The police had to come in and retrieve the children from the locked door. If he does post that, I'm asking for a GPS tether, a no-go to that address where the children were at.
The kids were not at the house at the time of the incident.
Right.
She's wrong.
You have the right
The
to
kids
remain
left
silent.
to their grandmother's house. They were gone.
The judge ignores Conklin's outburst and moves on to her decision regarding bond.
Having read the information that's been presented to me, I'm concerned for the safety of the family involved here, and I'm concerned for the safety of the community at large.
Yeah.
Are you done?
Didn't do a thing wrong.
Okay, so your bond is going to be $150,000
Yeah,
cash.
take that $150,000, shove it up your ass.
Thank you, sir. You're all set. You can let the jail staff know you're done.
Before he exits, Conklin has one final comment for the court. After spitting at the camera and delivering an obscene finger gesture, Conklin's escorted back to his cell. He remains in custody, and his case is pending. Next, we're in Taylor, Michigan for an arraignment. 47-year-old Joshua Lanto has been charged with interference with police activity, a misdemeanor. 4 weeks earlier, Lanto was filming and yelling at officers as they tried to conduct traffic stops.
People versus Lanto.
He was arrested and charged, and today, Lanto appears virtually before Judge Joseph Slavin, presumably to enter a plea. Representing the state is David Greco. Before discussing the case, Lanto's court-appointed attorney, James Gazicki, has a request of the court.
I'm asking the court right now if I could withdraw on this matter. I don't think I could adequately help Mr. Lanto in his legal arguments. And I'm just asking the court if I can withdraw.
All right. Then, Mr. Lanto, then I can appoint a different court-appointed attorney.
I don't want anybody speaking for me. As a matter of fact, I mean, all I really want is to be left alone. So that's first and foremost.
First, let me do the arraignment part. I need to let you know what exactly you're being charged with, all right? Now, it is alleged that while in the city of Taylor, that you violated City Ordinance 32-31, which is a charge commonly known as interfering with the police authority. That is a misdemeanor punishable by 90 days in jail and or up to $500 in fines. So, as to that charge, how do you plead? Guilty or not guilty?
The question's pretty straightforward, but Lanto has other matters he'd like to discuss.
Well, first, can I just make a few clarifications?
I'm going to caution you that anything you say can and will be used against you. So,
I understand. And you're stating that it's based on an interaction. So my guess is that you have no firsthand knowledge of anything that happened?
Well, I'm not stating anything. All I'm telling you is what the people of the city of Taylor have charged you with.
It seemed like you were getting a little angry. I don't know. I mean,
I'm not getting angry, sir. Nobody's trying to bamboozle you or anything like that. I just need to know if you're pleading guilty or not guilty. And if you're not answering that question, then I'll enter a plea of not guilty for you so that it preserves all of your constitutional rights and the case still moves forward.
Well, like I said, I would just prefer to be left alone and not have to come back at all. And my concern is we've got a police officer and we've got a prosecutor. Both are state actors and they're trying to bring charges against me. And I just want to know, because you are a judge and you are another state actor, am I going to get a fair and meaningful hearing?
I swore an oath to the Constitution that I put my hand on the Bible and swore to. And I'm telling you, I don't break my oath.
Okay, would you agree
that you're not going to get a fair hearing? That's my job, is to make sure that fairness happens, that due process happens.
Judge Slavin remains calm, even as Lanto questions the integrity of the court.
If the victim is going to be the city of Taylor and it's going to be presided over by a judge that is paid by the city of Taylor, then I have serious concerns for the fairness and the meaningfulness of these proceedings.
I am a judge of the 23rd District Court of the state of Michigan. It's located in the city of Taylor, but I don't work for the city of Taylor. And right now I can do one of two things. One, I can set this up for a pretrial, or I can just set it for a jury trial or bench trial right now.
This time, instead of answering the judge's one question, Lanto offers up a proposal to end the case.
I'm willing to forego any intention of criminal charges against the prosecutor if they're willing to just dismiss this now and leave me alone.
The judge has had enough and decides to wrap things up by scheduling a settlement conference between the state and the defendant.
I would advise. If there's a resolution, then there's a resolution. If there's not a resolution, then I'll ask if you want a bench trial or jury trial. All right?
Outstanding, because I'd like to talk to this prosecutor who I suspect is a criminal at this time.
The defendant may have finally crossed the line.
I'm going to caution you, Mr. Lanto. I'm going to caution you, and I'm going to caution you once. And the next time it happens, I will hold you in contempt. I do not run a Jerry Springer show. I do not run a Jerry Springer show where the litigants are going to use words and things and call each other names. Until you prove otherwise in a court of law beyond a reasonable doubt, you are not to call any other litigant a criminal.
Lanto decides to heed Judge Slavin's warning.
Okay, I certainly appreciate you being fair.
I swore to do. That's what I always do. Have a good day.
Thank you.
The judge went on to grant Gazicki's request and removed him from the case. As for Lanto, he's been assigned a new public defender and his case is pending.